you have the defendant, the defense attorney, you're gonna have the prosecutor and the judge. And of course, they're going through the process of what happens in a criminal case in a courtroom. Okay? Thank you.
Next up, indictment number 3123, calendar year 2013. Defendant Edward Camacho. Attorneys?
Nazdin Malik for the DA's office.
Julio Pabon for the defense.
Judge, the charges in this matter are robbery in the first degree, criminal possession of a weapon in the third degree, assault in the second degree, 2 counts of grand larceny in the fourth degree, possession of stolen property in the third degree, and petty larceny.
That's correct, Judge.
The defendant pleaded not guilty at arraignment. Is there an offer on the table?
I do have an offer for the defendant at this time, Your Honor. May we have a few moments to discuss?
That's fine.
Thank you.
Good morning.
Good morning, counsel. Counselor, your client is looking at a lot of time here. I can offer 5 years probation, YO status. We'd seal your client's record. That's only if he's going to plead guilty to robbery in the second degree, and that would be in satisfaction of the entire indictment.
I don't think he's going to go for that because, as you know, he says he was at home and he didn't do it. I'm sure you've seen he has a clean record. Can you offer anything better? Is your case that strong?
We have enough evidence to proceed forward.
Well, clearly you have something, or else we wouldn't be here. I need to be able to advise my client with something. Can you at least let me have a copy of the grand jury testimony so I can get a sense of things?
Well, counselor, you know that doesn't come until later. I'm offering your client a good deal. He should take it.
But with nothing to base it on? As far as we know, all the evidence shows is that someone did it. He says it's not him. If the evidence indicates otherwise, I might be able to reason with him.
I'm not here to help your client, counsel.
Granted, but it would be much easier for both of us if we had something to show him.
All I'm authorized to give you right now is just the offer.
Fine. I'll talk to him.
Okay.
So come on, what's up? I mean, they're gonna drop this, right? Because like I told you, like I said earlier, I didn't do this. I don't even know what's going on.
Not exactly. They're offering YO status, 5 years probation, and they will seal your record if you plead guilty to robbery in the second degree.
Hold on. First of all, what is this YO and this 5 years probation? Listen, I've been coming to court now like for 8 months. You know what I'm saying? And I don't even know what's going on. No evidence or anything. So what do you mean?
Well, we don't know what they have exactly. They say they have evidence. The problem is we don't know what it is or how strong it is.
Yeah, but you're saying I want to know what the evidence is. I mean, tell me. I mean, they want me to take a plea without even knowing what they got against me? I mean, come on. This is not justice. I mean, come on. I didn't do it.
So it's hard to assess what the risk is if we go to trial without knowing what the evidence is. I can tell you that if they do have a strong case, robbery in the first degree carries 2 to 25 years in prison, which is probably a lot longer than what they're offering. On the other hand, if you want to fight it, you said you don't have an alibi, right?
No, because I told you I was home asleep. I was watching the game and then I fell asleep. But I'm telling you, I did not do this. And then I just woke up and I went downstairs to go to the store. And before I knew it, the police grabbed me and told me that I robbed somebody.
Look, if you want me to fight it, we can file certain motions to force the prosecution to hand over some of the evidence. But that could take a long time. And in the meanwhile, you're going to be locked up.
Hold on. You're telling me, I said this has been going on for over 8 months and no one has told me anything or showed me anything, and then in the meantime, I have to sit in jail and just wait?
At this point, since we can't know exactly what the evidence is, we have to consider the possibility that a jury may find you guilty, Edward, regardless of whether you did it or not.
Man, this is not right, man. I mean, I'm telling you, I did not do this, man. You got to help me out. You my lawyer. I mean, get some of this evidence and let's look at this evidence.
But it isn't fair. You're right. But that's the reality. I can't sugarcoat it.
Counselors.
Just one more morning, Judge.
Okay.
Eddie, what do you want to do?
Listen, I want to fight this because I said I didn't do it. But it's hard for me to fight anything when I don't know what they got against me. I mean, come on. I'm telling you, I do this. I never been arrested a day in my life. You know what I'm saying? So how can I take a plea to something I didn't do?
Listen, I know how you must be feeling. Scared, frustrated, but remember, we don't have to prove anything. They do.
Yeah, but you know, how can I trust this court system when I'm here in the first place when I said I didn't do it? You know, but yet and still, she wants me to plead out to something. You know, come on, man. I can't go to jail for something I didn't do.
Well, let me see if I can get the judge to intervene.
Yeah, please.
Your Honor, my client maintains his innocence, but without knowing what evidence the prosecution has against him, he feels the risk of going to trial is just too great.
Hold on. What about it, Miss Malik? Are you in possession of evidence that you failed to turn over to the defense?
Respectfully, Your Honor, I haven't done anything I'm not authorized to do under the law.
I'm aware that you are basing your actions on Criminal Procedure Law 240, but you are aware that your role as a prosecutor is not just to mete out convictions, but to hand out justice.
Yes, Your Honor, but respectfully, as both you and defense counsel are aware, under CPL 240, I'm not required to produce any evidence until I'm sure I'm going to use it. Now, if defendant takes my offer, I won't be using any of that evidence.
And you think that's fair?
With all due respect, Your Honor, it's not up to me to say what's fair and what isn't fair. That's what the law is.
Again, counselor, your purpose as a prosecutor is to do justice, not just seek convictions. CPL 240 doesn't prevent you from turning over the grand jury transcript to counsel here, or giving him the names of witnesses in case there's exculpatory evidence that might exonerate his client. Is that not correct?
That's true, Your Honor, but at the same time, with all due respect, CPL 240 doesn't require that I turn over any information at this time.
Madam ADA, okay, you're not supposed to turn it over, but is there any language specifically prohibiting you from turning over this information to counsel?
No, Your Honor, there isn't. But again, it doesn't require that I do so.
Miss Malik, I cannot force you to turn over this evidence, but in good conscience, I strongly urge you to at least turn over the transcripts to counsel here.
With all due respect, Your Honor, under CPL 240, I don't have to turn over the grand jury minutes until the start of trial.
There's something seriously wrong with this law, CPL 240. Very wrong. Defense counsel, are we ready to go to trial?
May I have just another moment to discuss with my client?
Yes.
Your Honor, please.
Yes, please make it fast.
Eddie, you saw what happened. I tried to get the judge to intervene, and you saw that she tried, but her hands are tied. We're going to have to make a decision without knowing what evidence they have.
What do you mean her hands are tied? She's a judge. She's nothing but an ADA. You know what I'm saying? What do you mean?
I know, but look, the law gives the DA an advantage. The law doesn't give the judge the authority to force the prosecution to do the right thing. We have to make a decision. Do you want to fight this or you want to take a plea?
Man, I gotta fight this because I tell you I didn't do it. But what I'm saying is I need to see something. You know, what are they saying I did? Man, they may not even have any evidence. I mean, for all I know, I don't want to plead to something that that I don't see. I need evidence to make a decision here.
Look, I'm in the dark just as you are. We can fight it, but I can honestly tell you that's a risk. If they have anything that looks like it could be you, if they have someone that has a mistaken witness, it's a huge risk with a lot of years.
Yeah, man, and they call this justice, right? And I have to make a decision. I can't make it. I got to make a decision now. Well, I can't make that decision. I have to speak to my mother.
Judge, my client would like to discuss this with his mother. Could we have a few days?
The wheels of justice are turning. You don't have a few days. Please have your client talk to his mother, and you're to come here tomorrow at 10 a.m., and you either go to trial or you take a plea. Is that amenable?
Yes, thank you, Your Honor.
All right, I'll see you tomorrow at 10.
Ay, ma.
Ay, mijo, ¿cómo está?
Ahí, tranquilo. Bendición.
Dios te acompañe.
Ay, María, hace un calor allá afuera.
Sí.
Ay, María.
Cuidado, mijo, cuidado.
So what happened in court?
They're saying that if he says he's guilty, he won't have to go to jail. They'll put him in some kind of parole and do something with the record so that no one will ever know.
Probation, ma, not parole, probation.
Está bien, Eddie, está bien.
Calm down, Ray.
Calm down, bro. Calm down. You know, what is all this about probation and maybe no jail time?
Listen, my lawyer told me that if the DA says if I copped out, right, that they'll give me this YO and they'll give me 5 years probation, you know, but I got a cop-out plea, but I don't see no evidence.
Wait a minute. Cop out? What are you talking about, the plea? What's a plea?
Ray, they really think I did about putting a knife to this woman's neck. They really think that I did this, man. I don't even know what they're talking about. I was home watching a game. I fell asleep, you know, and then when I got up, you know, after a while, I went downstairs to the store, and then the police grabbed me, and then I'm here. You know, it's going on 9 months, and they haven't shown no evidence. Every time we go ask my lawyer, you know, he keeps saying something like 240, no evidence. We can't see no evidence. It's like 240. You know, I can't give you nothing, but some lady took the stand at the they got grand jury, and they got a statement, but we can't see nothing, man. Yeah.
Well, did the lawyer show you the statements? Or what the witness says in the grand jury? Ma, tú estabas en la corte, you was in court.
Every time I tried talking to the lawyer, Ray, he looked like he was trying to ignore me or something. You know, he just wanted to talk to Eddie. I asked him, where's the proof that my son did this? I don't want my son going to jail. I felt like I was really going to start to lose it with this lawyer because he's not giving us any evidence. Eddie kept asking him, where's the evidence? And he had no evidence. I told him to his face, you must be working with the DA. You must be working with the DA. You have no evidence against my son. You say you have evidence, but you don't have any evidence. We haven't seen anything.
Wait a minute. What did the lawyer say can happen if you don't take the plea? I mean, if you go to trial and get found guilty, you know, we got to know how much time can you get.
Mijo, why are you asking him? Why are you asking him that?
Well, you know, we got to find out what's happening.
They're not giving us anything. They want him to take a plea. They want him to take a plea, Ray. They're not giving him anything. The only thing I know is that I don't want my son going to jail. I want him to take the plea because I don't want my son going to jail. I want him to come home with me, Ray.
Well,
I don't want to hear anything else. I want him to come home with me.
Well, is that what you're going to do, man? Cup of plea?
Why are you asking him what he's going to do? I already told you what he's going to do. He's going to cop the plea because he's not going to go to jail. You know what happens in jail. They get killed, they get raped, all kinds of things happen in jail. My son is not going to jail. My son is not going to jail. It's not happening to my baby. He's going to come home with me.
Yeah, ma. Listen, I don't want to see this happen to Eddie either. But Eddie says he didn't do it. Eddie, did you do this, man? Tell me the truth, man. Dime la verdad, man.
Hey, coño, Ray, what's wrong with you? Ray, what's wrong with you? You sounding like my lawyer. I tell you, I didn't do this, man. I was home watching the game, and then I fell asleep. You and Ma usually are home. You wasn't home, man. So I woke up and I went to the store, and I keep telling you, man, I don't know what's going on here. I never seen that lady. I never use a knife on nobody, man. So what's wrong with you, Ray? Yeah, you say take it easy. I could go to jail here. My life is messed up here, man. And you sounding like my lawyer. You know what I'm saying? You don't believe me. You're my big brother. And you don't believe me. You know what, Ray? You know what? Maybe Ma is right. You know, maybe Ma is right with this lawyer. Because every time we ask the lawyer, you know, for some evidence, all he keeps saying is, I don't have no evidence. They can't give me something like 240. I can't get this 240. But you know what? And I'm thinking like, Mom, maybe my lawyer is working with the DA to just send me up the river. But you know what? I'm thinking maybe I should just take this plea, even though I didn't do it. I should take this plea, do the 5 years probation, then maybe after that I could just maybe go to college, put my life back together or something, you know. But what really bothers me and what really hurts me is that I never been arrested a day in my life, never had no problems. And I'm gonna be pleading guilty to something that I didn't do. And that's what really bothers me, man.
Well, Eddie, if that's the way you really feel, maybe you should take it to trial. If they're offering you probation, no jail time for an armed robbery, man, that means they got a piss poor case against you. And I think that that's the reason why they want you to cop a plea.
Ray, what are you trying to do, mijo? What are you trying to do?
They don't have anything. They don't have anything.
Mijo, there's no guarantee. There's no guarantee,
So you
Ray.
take a chance.
There's no guarantee if he goes to trial, mijo. We don't have any money for an attorney. We don't have the money, mijo. What are we going to do? I don't want your brother going to jail. What are we going to do? We don't have the money, mijo. We don't have options here.
Yeah, but if they're offering them a probation for that case, that means they don't have anything.
Ray, yo sé, mijo, but we don't have the money for an attorney. No hay dinero. We have no money. There's no options.
Go ahead, Mom. Eddie's taking us. Say to me.
I'm going to tell you, Ray, I want my son taking the plea. Your brother has to take the plea. Let him take the probation. This way he can come home and there's no jail.
Well,
That's it.
that's it.
Good morning, everyone.
Good morning.
Defense
Good morning.
counsel, are we going to go to trial?
My client has decided to.
United will never be defeated.
Hi, good evening, everyone. My name is Zanali Tirado. I'm an attorney. I began my career with the Legal Aid Society. I then went into immigration law, and I'm a solo practitioner, and I became involved with Discovery for Justice at its inception. I'd like to introduce my colleague, Chuck Berkeley, please.
Hello, everybody. My name is Chuck Berkeley. I'm a retired New York City detective. And one day I was called in, a good friend of mine called me in. And as being a detective for 20 years, I did not know that the criminal justice system worked like this. And I locked up a lot of people, and I thought that the criminal justice system was on the line, you know. And when I found this out, I said, you know what, something is wrong, terribly wrong, and I'm doing all I can to overturn this, because what you see goes on every day in court. And it's not that the district attorney doesn't have the evidence, they refuse to give up the evidence. And something is wrong with that when they want you to take a plea and you know you're innocent, but you don't have money for an attorney and you're sitting in jail, and 9 times out of 10, what happens is people take the plea. So I know something is wrong with this, and I'm gonna do everything I can to hope get rid of CPL 240 and then Act 245.
Okay, good evening, everyone. My name is Vincent Avagliano. I'm an attorney, and I'm also a member of Discovery for Justice. I came to this issue approximately 6 months ago, and I've known about it for a very long time through friends that practice criminal defense law, and it's something that has existed in New York for a very long time. Unfortunately, many people aren't aware of it. So I thought that what better way than to participate in a forum like this so that we can bring the attention to the public, so that you are aware of it, and then hopefully we'll have the opportunity to make changes here in the state of New York that have been made all across the country to make this a fair playing field for everyone.
Let us begin now, and I'd like to introduce all of you to the panelists. We have Judge Mark Dwyer, Supreme Court Judge in Brooklyn. He is a co-chair of the New York State Bar Association Task Force on Criminal Discovery Law and chair of the Criminal Justice Section of the New York State Bar Association. Judge Dwyer is also a former prosecutor. We have John Shuffle, with the Legal Aid Society, Criminal Defense Special Litigation Unit, author of the 2009 report on criminal discovery reform in New York, member of the New York State Bar Association Task Force on Criminal Discovery. We also have, representing from New Jersey, from the New Jersey County Prosecutors Association, Carol Novi Catuango. She is a senior assistant prosecutor, trial chief, Bergen County Prosecutor's Office. I'd like to mention at this time that invitations were extended to the local district attorneys and the DA's Association to provide panelists. However, they declined to attend.
Okay, oh, sorry. Okay, so we're going to start with a brief excerpt that I'm just going to read to you from an unlikely place. This article comes out of Texas, and it's about the New York State criminal justice system. Alberto Ramos was a 21-year-old college student and part-time substitute teacher's aide, aspiring to be a teacher, when he was accused and then convicted in 1985 of raping a 5-year-old in the Bronx daycare center where he worked. In a case based largely on the child's sworn testimony, Ramos was accused of taking a girl into the concourse daycare bathroom during nap time. She was found to have vaginal bruising, and her grandmother testified that when she picked her up from school, the child was crying. Amid media-fueled hysteria over a wave of child sex abuse in daycare centers, Ramos was found guilty. Joel Rudin, who laid out the Ramos case in the Fordham Law Review in 2011, writes that when Ramos was convicted of 2 counts of rape in the first degree, he screamed in agony, "Kill me." In 1992, the conviction was overturned after the alleged victim's mother filed a civil suit against a New York City-funded daycare center and Ramos. Now, this is Ramos being sued, not Ramos trying to reopen his case. In the process of Ramos being sued, the city's insurance settled, but a civil defense attorney who was able to obtain evidence that Ramos did not have access to before his criminal case believed Ramos was innocent. The lawyer got permission to share the information with Ramos, who had been suffering severe abuse in prison for 7 years on an 8 1/3 to 25-year sentence as a child rapist. Among the omissions that could have aided Ramos's defense was a log showing that the grandmother who testified against him had not, in fact, picked up the girl from the daycare center that day in 1984. There was evidence showing other reasons for the child's vaginal irritation and an interview in which the girl had initially denied that Ramos raped her. None of it had been turned over. I'd like to open this up to the panel for reactions and comments, and we'll begin here. Familiarity with this case, Mr. Schofield, Judge Dwyer, Ms. Cachuango, and any comments.
Well, let me say first of all that no amendment of the discovery statutes will do much good if DAs and police officers are going to suppress exculpatory evidence. Some of what you were talking about there is evidence that even under current rules is obliged to be turned over quite early. I'm trying to use the mic. Okay. you can't change human nature by changing the law, and you're still going to have some problems with people who would do that, but that doesn't mean you shouldn't change the law. Let me add quickly that I'm not here speaking as a judge. I'm here because I was part of the task force on criminal discovery that the State Bar Association put in, along with John. We issued a report in December, and it advocates for discovery reform, and I'm here mostly to talk about the report. We will be delighted, though, if the contents of that report are the occasion for discussion in fora like these.
Well, I think disturbing stories like that show how people get exonerated and shown to be innocent after a conviction, largely by luck when it happens. And we've all seen so many exonerations in recent years. But because there's no rule that the evidence has to be turned over, it's just by luck that many of these people have exonerated themselves and shown their innocence. And I think that if these reforms were enacted and an open discovery system were in effect throughout New York, we wouldn't have as many of these wrongful convictions because the evidence would be in the open, and people who are wrongfully convicted would have a much easier time avoiding those convictions and showing their innocence.
Yeah. And, sorry.
I'm sorry, if I may. I'm just a visitor here in New York these days, but I'd like to agree with what the comment that the judge did make, which is that the story that you were talking about is exoneration because of evidence that was withheld. And regardless of the current state of the discovery rule in New York, if there was exculpatory evidence, every prosecutor knows they're under an obligation to turn it over. We have all heard horror stories where that has not occurred, and there's no excuse for that. But the changes or the amendments that are recommended for 240, as I understand it, which again is that I'm speaking a foreign language because I'm from New Jersey, but as I understand it, that is not going to change what you spoke of. And earlier turning over of discovery, those would not necessarily have impacted the end result in that case, unfortunately.
How would you address possible witness statements if New York did have mandatory discovery disclosures earlier on, and then perhaps how that compares to the situation that Mr. Schofield has pointed out, as opposed to relying on pure luck, perhaps actually just having it by requirement, because it seems that in this case, at least in 1985, it wasn't obviously mandatory, despite the fact that this evidence was withheld.
Well, it strikes me that the current rule, which not all prosecutors' offices follow in New York, but the current rule, as in the example given in the video, does allow the DA to sit on witness statements up until jury selection time. And that obviously makes impossible, in cases like that, a rational consideration of what the defendant ought to do. Pretty much any defendant would jump at a YO and 5 years probation in a robbery case, but in a lot of other cases it's a difficult decision. And you cost the whole system by delaying things the way they are delayed. The mayor is now very hot to get cases disposed of more quickly so that the Rikers Island costs aren't so high and such, and that makes perfect sense. One way you get them done more quickly is by having discovery earlier, and the public will benefit greatly from that, even apart from the justice that will be done in particular cases.
Okay, I'd like to turn your attention to another part of this article. And the article, as I mentioned, is from Texas. The title of the article, which is, it's only about a year old approximately, it's from April of 2014. It's got a picture of Governor Rick Perry signing into law an open file discovery law in the state of Texas. And it's titled, "Will New York Follow Texas in Criminal Justice Reform?" There's another heading in the article where it says, where the heading reads, "Out-reformed by the Lone Star State." So the question I have to the panel is, what sort of twilight zone are we in where Texas of all places, raises the bar as far as criminal justice rights, and the hope is that New York will follow Texas's lead?
Governor Governor Perry has always been pandering after the liberal vote.
I'm going to take that as a Freudian slip.
I can tell you right now, our task force surveyed the laws that apply in every state as far as discovery. And as of today, New York is one of only 4 states where the defendant has no right to learn the identities, or no way to learn the identities of the people who are accusing him or her of a crime. The others are South Carolina, Louisiana, and Wyoming, plus New York. Every other state has some mechanism where the prosecutor has to disclose relatively early in the case who the witnesses are, so the defendant can make an informed decision. But what am I going to do in this most important time of my life? To investigate the witnesses, prepare a defense, interview witnesses, find other evidence? And New York has fallen behind all of the states in the country in modernizing this most important rule.
I think it should be emphasized, too, that the task force did not say that there will never be an exception. We obviously recognize that there are some defendants who are objectively very dangerous. Gang cases, for example, are very significant here in the city. The prosecutor can certainly be allowed to make a showing in a particular case of need for keeping identity secret, and we make that prominently clear in our report.
Can you explain to the audience what exactly is meant by discovery?
Well, discovery is the process by which both sides share certain information that they plan to introduce into evidence, if they do. So that would be like statements of witnesses, the identity of witnesses, recordings, photographs, those sorts of things that are going to be the building blocks where they the prosecutor tries to prove the defendant is guilty, and if the defense chooses to present a case, it would also disclose certain types of intended evidence. It's before trial you exchange certain information so that the opposing side can research and evaluate, and as in the video presentation, so that the person who's accused of a crime can make an informed decision about how to defend him or herself or whether to accept a guilty plea.
Can the panel describe the difference between discovery in a criminal trial as opposed to discovery in a civil trial?
Well, in a civil trial, and I'm no expert on civil cases, but in a civil trial, discovery is extraordinarily broad. For example, you have depositions of the other side's witnesses. In criminal cases, that's done very rarely. In Florida, I think they have depositions as part of their pretrial discovery process. But in most states, and especially in New York, there is nothing like a chance that's given to you to interview a prosecution witness on the record. You may be able, if you find out who the witness is, to send an investigator to talk to the witness, but you get nothing like deposition type testimony. In addition, you basically, in a civil case, give your file to the other side, and the other side can look at it to its heart's content. And again, nothing like that happens in New York in criminal cases.
So it's fair to say that when there are dollars at stake, you receive your evidence long before trial. However, when your actual liberty is at stake, you're whistling Dixie. You're waiting around.
It's fair to say in New York, but in other states, including New Jersey, they have enacted broad discovery in criminal cases. Like New Jersey has had broad discovery in criminal cases since 1973.
Wow.
It's only in New York and a few other states that have yet to address this issue that there's this great disparity.
If I may, I agree with counsel. Of course, New Jersey's discovery statute is quite different than that of New York. And I understand from what you're saying that there's only 4 states that have similar discovery statutes to that exists here in New York. But it should be commented on that it can be, it's a considerably more complicated conversation than just the discovery rules. And the reason that I say that is because it's a little impractical to compare the discovery rule of one jurisdiction against the discovery rule of another jurisdiction without looking at the entire code or procedure law from which they come. And one of the reasons that I say that is because, for example, in New Jersey, a criminal defendant is entitled to what's called automatic discovery. They don't need to make a demand or a request for it, and the discovery is provided after indictment. In New York, the current discovery law allows for certain discovery after indictment, but there does have to be a demand by counsel for the defendant. One of the things that exists in the state of New York, however, that does not exist in the state of New Jersey, are very strictly enforced time limitations about when cases have to be presented to a grand jury and indicted. For example, what's commonly referred to as 18080, where there's a period of time that the defendant's incarcerated, that the matter has to be presented to the grand jury if that defendant is going to be continued to be held in on bail. So what that does is that the presentation to the grand jury, if they vote for an indictment, that triggers defendant's ability to then request or demand that discovery. New Jersey, as I said, is automatic after indictment. Pre-indictment, you're not entitled to discovery. But in New Jersey, there's no 18080 requirement. So our automatic discovery may come after an indictment, but it may be a longer time to get to the indictment than it would be in New York. And that's just one example of differences that exist in these systems. So sometimes it's a little bit of an unfair comparison to compare simply one provision with one from a foreign jurisdiction without looking at more of the whole.
We'll look through the provisions as much as we can in a way that the audience can digest as we continue through some of the questions for the audience. And please feel free to give the Jersey perspective as we've included you on the panel to do so, and we appreciate you doing that. I'd add one point since we're comparing laws. We're in a union. We're invited here by 1199. There may be many union organizers, officials, business reps in the audience. I don't know how many union folks are familiar with the fact that up until very recently, the federal law didn't require that in a union setting, if you had a labor dispute, that you were not entitled to witness statements. But even in the union setting and in a labor dispute setting, that law was changed where now even in a union setting where you have a labor dispute, which is called a grievance, you're entitled to the witness statements in your investigation as far as finding out what you've been accused of or what the wrongdoing is that your employer claims that you participated in. So that just goes to give a different flavor since we were comparing criminal and civil law. Now you have a bit of labor law for folks in the building that participate and that understand the union perspective. But I'll turn it over for another question.
And why is that? The ADA in the video said that the law does not require her to turn over evidence. What is she referring to? What is Criminal Procedure Law 240?
Well, Criminal Procedure Law 240 is the statute, the set of laws that set the rules for what evidence the prosecution has to give to the defense, and then the defense has to give to the prosecution. And the ADA was correct there. In New York today, under 240, which is this law that has not been changed in several decades in New York, you have no right to get the police reports in your own case if you're accused of a crime. You have no right to learn who is accusing you or who are any of the witnesses against you until you walk into the courtroom at trial. So for example, in Manhattan today, the Manhattan District Attorney's Office, in virtually all felony cases where they're accusing you of a felony, they do not tell you who is making the charge against you. What you get in the criminal court complaint in any felony case is a person known to the district attorney's office has accused you of robbery, murder, rape, whatever it is, or a person known to the grand jury. And you as a defendant have no right and no way to learn who those things are, even if you don't pose a threat to witnesses, and even if there's no danger concern, they just do it as a matter of common practice. And because of Article 240, you as a defendant have no way to learn that information. And the appeals courts in New York have said, unless the legislature changes 240, judges can't order disclosure. It's not something the prosecutor has to provide. It's up to them if they want to provide it.
So are you saying that when someone is arrested and accused and they're waiting for this evidence, where usually are they waiting for this evidence?
Well, Like the prosecutor said, if there's a felony case, you have a right to a quicker indictment, basically a vote by the grand jury. If it's a misdemeanor case, you don't have that same, you have a right if you're incarcerated to a quicker charging document. If you're incarcerated, if you're not incarcerated, the prosecutor has a much longer period to get this. So where you are, if you're incarcerated, you'll get the information, you'll get an indictment sooner, but you won't get the police reports. You won't get the witness statements. You won't get the witness names until you get to a trial, which could be, 6 months later, a year later.
And if you mean literally, where are you? Very often you're at Rikers Island.
And I think that's the question. Where are you physically?
If you're incarcerated, you're at Rikers Island. If you're not incarcerated, you're coming to court time and time again. Sometimes you have to come to court 10 different times before you get to a trial, 15 different times. And that, if you have a job, or if you have a life, that's a tremendous imposition as well. And during that whole period, you're not going to have witness statements in most of New York State. Only if the prosecutor wants to give it to you.
If I can jump in and point out another distinction between New York and New Jersey here, in discussion about the presentation to the grand jury, in all felony cases, a grand jury hears evidence and determines whether or not an indictment or a formal charge should issue. And one of the differences about New Jersey's discovery rule is that, in fact, included in that automatic discovery I talked about are witness statements. So we do provide defendants early on in the process, or as after indictment, with the names of the witnesses who may be called at trial to testify against them. One of the fundamental differences, however, in the system between New York and New Jersey is that presentation to the grand jury happens, it's the same in both states, but it happens without a defendant being present and no attorney for a defendant. This is simply where a prosecutor or a representative of the state or the people puts forward their proofs, and the grand jury determines whether or not there's probable cause to believe that the defendant committed the crime, and they decide to choose to formally accuse or indict this person of the offense. And the reason that it's an important distinction, what I want to say is an important distinction, is because in New Jersey we do turn over victim statements. However, hearsay is admissible in the grand jury. So in New Jersey, the grand jury themselves may never hear from the accuser or the witness. They may hear their testimony, the witness's story or the version through a police officer or through a recorded statement. But there's no requirement that we call a witness to testify. In New York, even though the victim's statements or the witness's statements are not turned over to the defendant, that grand jury proceeding does not allow for hearsay. So those real people have come before the grand jury and they have testified. So there is a considerable difference there underlying those differences. And the reason I bring that out again is simply because it's not just apples and oranges. There's a lot of complicated other rules that are implicated in all of this.
It also has to be remembered that there are costs to the discovery changes that have been proposed. It's not just in an obvious case where you've got a gang leader that a witness might be threatened, intimidated, and might decide not to go forward at trial. It can happen in any case, and you can't predict them all. But the states that have changed to more liberal discovery and that do reveal witness statements and names in almost all cases in advance have never found it to be so big a problem that they go back to the New York system. The benefits to the system and to justice overall plainly outweigh the costs. How many witnesses have you lost in your career?
Well, Doug, I think that's a little unfair. How many have I lost? You mean because they've been threatened? Because they've been identified and they got cold feet, walked away, or perhaps were forced away. I couldn't tell you a number, but I can tell you quite a few. And sometimes, again, in fairness, it's not all because their names were turned over. For many, many years, I concentrated in domestic violence work. And the names of witnesses in domestic violence work is really not of any relevance because by nature of the type of crimes that we're talking about, the parties are intimately known to one another. So there are instances of threats, of violence, and witness intimidation across the board. I agree with you in all types of cases. But I have had, and I think every assistant prosecutor or assistant district attorney would tell you that it is a constant conversation with victims of crime. And I understand, and I hold my obligation under Brady to turn over exculpatory material to a defendant, and I understand how important discovery and making an informed decision is to a defendant. But there is another side to this story, and that's the side of the victims of crime. And I'm not suggesting that innocent people should be convicted or people should feel that they don't have options when it comes time to plea. But I think every assistant prosecutor who comes before you would tell you that it is a constant conversation with victims, whether the defendant is known to them or not. And sometimes it's a real, even after the names have been disclosed, it's a matter of walking into the courtroom and facing great fear. I've seen, in my career, I've seen judges who have been threatened. I have seen assistant prosecutors who have been threatened. I have seen witnesses who have been assaulted and then have testified. So I couldn't tell you a number, but I do think it is a very real concern, and I'm sure it's a concern for the defense bar as well.
Ms. Catuongo, just not to
correct you and say it's Coutinho.
Coutinho. Oh, okay, Ms. Coutinho.
Thank you.
Thank you for the correction, and thank you for the personal experience that you shared with us. We're going to discuss some of the issues regarding witnesses and witnesses coming forward as we proceed through the panel. So let's see if we can move on to some of that. But a quick question directed to Mr. Schoeffel. This vignette, and I think you alluded to this, the vignette that we viewed on the screen, how often does that play out on a day-to-day basis?
That happens on a daily basis. I mean, we have to make one distinction. In Brooklyn, the prosecutor, District Attorney Thompson, has voluntarily adopted a different policy where he provides this information. So if you're being charged in Brooklyn, you're at a much better advantage, and conversations like that don't happen as often because they've just decided it's unfair to defendants. We're going to provide you police reports and witness statements whether the law makes us or not. So, you know, we have to applaud a prosecutor's office where they've decided to be fair. On the other hand, if you cross the East River, for example, in Manhattan, the prosecutor takes the strictest, hardest version of any prosecutor in the state, where they play hardball and they will give you the witness statements, if you're lucky, the night before trial, or maybe the Friday before trial if you're starting on Monday. By and large, they play very strictly, and those conversations happen all the time.
And
in Queens and the Bronx as well, you find those conversations happen on a regular basis because the defendant just doesn't know enough about the case to make an informed decision.
There are, in fact, a lot of other problems in the criminal justice system, even in my home borough of Brooklyn. For example, turning over witness statements includes turning over grand jury testimony. And in some of the big narcotics cases that I've supervised, they have reporters in the grand jury who are temps. And it can take 6 months for them to produce the grand jury minutes for me to review for legal sufficiency, and then they go over to the defense. So that kind of a conversation can happen in Brooklyn if the DA wants the case resolved quickly and says, take the 3 years today, even without seeing the grand jury minutes, or else. I mean, it can't happen.
It can happen. And if you did want a particular piece of evidence, Mr. Schoeffel, what is it that you have, as a defense attorney, what is it that you have to do now under the current law, 240?
Well, you have to make a demand in writing for evidence to trigger 240. But the biggest problem is, even if you make that demand, you may not have a right to that statement ever. Like, there is no requirement, and you have no right as a defendant to all of the police reports.
So essentially, are you making a request for evidence that maybe ultimately you're not entitled to?
Well, sure, yeah. If the prosecutor is going to play strict, they're going to only give you those police reports. It gets a little technical, but that the statute requires them to give based on which witnesses they choose to call at trial.
And you may never get them.
You may never get them, and if you are entitled to them, like I said, you may get them as you walk into the courtroom for your trial. That happens regularly, routinely, and how are you as a defense lawyer supposed to read this information, process this information, investigate your client's case, This is the first time you know what the evidence is. How do you prepare? How do you defend your client in a courtroom? And that's why it really is institutionalized trial by ambush, because you can't do it. You do your best. And I work for the Legal Aid Society, which is the main public defender's office in the city. And we have a staff of investigators who will go out at the last second and try to do those investigations with new information. But the lawyer's in court doing the trial, and it's just an inherently unfair system, and it can lead to wrongful convictions.
And so while your client is waiting for this evidence, and he or she can't make bail, she more or less, or he is sitting in jail just waiting for this evidence to be produced.
That's right. That's right. And there's often, if you think about the subtleties here, if you're charged in Brooklyn, like I mentioned, and with the caveat that Judge Dwyer said, sometimes it comes really late because of the time it takes to create transcripts. But you at least have the police reports. But you may be sharing a cell with someone at Rikers Island who is being charged in Manhattan, and they don't have those reports. And the person in Manhattan who's being charged with a crime cannot understand. How is it possible my cellmate has all his police reports, he can prepare his case, but the prosecutor in Manhattan won't let me prepare my case? Why should the quality of justice depend on which side of the East River you're being charged in? But that's the way it is today in New York City.
Okay, and I know that usually in the Bronx and certain counties, right, a person could sit in jail about 1.5 to 2 years before the average trial takes place, right?
Yeah, that's been covered in the newspapers. The New York Times has run a long series on. There are people who have. Right now, there are people who have been sitting at Rikers Island for 2 years and more than 2 years, charged with a crime, and these are the people who are determined to defend themselves. And if there's a guilty plea offer, not to take it, but they cannot get their case tried in court. And during that period, many or most of them do not have discovery. It's up to the prosecutor if they want to provide those witness statements.
The reason for that delay in New York is attributed to what?
Several factors, but the Chief Judge of New York is looking at courts, the trial court's contributions, lack of resources, prosecutors' inefficiency, defense delay, several factors.
The only reason I ask that is so there's another distinct difference between New Jersey and New York practice, and that has to do with the right to a speedy trial. You do, of course, have a right to a speedy trial in the state of New Jersey, but it is not as well defined as it is in the state of New York. So, for example, in the state of New York, under a section called 3030, the state has a finite period of time before they must be ready for trial. So I don't disagree with counsel that defendants wait longer than that 6-month period where the state has to be ready for trial. I simply would say that there is a protection in New York that requires the state to be ready for trial within a certain period of time, or the charges are dismissed. In other jurisdictions, it's a little more an amorphous standard. So, for example, there's as I said, a constitutional right to a speedy trial in New Jersey, and we have great delays as well. And a lot of it has to do, as counsel said, with lack of resources. The courts are busy. I'm sure the judge will tell you the judges are working harder than they should.
So you're saying that each state can enact their own criminal procedure law, and usually they're similar.
No, what I'm saying actually is each state does enact their own criminal procedure law, and there are sometimes great differences. But I think what I'm saying is when counsel was commenting on the delay where defendants wait for trial, and I do not dispute that, I agree with him. But that is a separate discussion, or perhaps a subsection of this discussion, because it is not that defendants are waiting simply because the prosecutors are refusing to go forward. There's an obligation on prosecutors in this state that they must be ready within a certain period of time. There's other elements at play.
Okay, but that statute she mentioned is a huge piece of Swiss cheese.
Okay,
it is not really a speedy trial statute. It's really many people argue it's a delay statute.
And this law, CPL 240, which allows the district attorney to withhold exculpatory evidence. This is unique in New York, but this must be a model across the country?
Well, actually, the New York statute does not allow withholding exculpatory evidence. the prosecutor may not realize that certain evidence is exculpatory because sometimes only the defense take on information can show how it can help the defense. But the Constitution requires that Brady material, that is exculpatory material, be turned over to the defense as quickly as is reasonably possible. Some prosecutors in New York, as the report mentions, take a narrow view of what Brady material is. They think Brady material is only that which is material in their mind to guilt and innocence, and a prosecutor's view of that may not be the same as an objective person's view of that. Most people elsewhere think that the prosecutor has to turn over everything exculpatory, whether it's material or not, and that's for legal reasons that I won't bore you with now. But Brady material does have to be disclosed.
Oh, okay. But so just let me say that more or less that there's other states that do allow early and open discovery, but that New York is lagging behind with other states that do not.
Yeah, New York lags behind, definitely.
Question. Isn't it the law, even if it is not the law by statute, then the law by cases, even Supreme Court cases, that evidence be turned over to a defendant?
Well, certain evidence that can help a defendant, the person accused of a crime, show that they're innocent, or that the important prosecution witnesses are lying. The U.S. Supreme Court, several decades ago, said if a prosecutor has that kind of evidence that can show someone is innocent, they have to provide it to the defense. Now, that's an important rule, but the way the courts have limited that rule, while it's important, it's not adequate. It's quite a narrow rule. And like the judge said, we won't bore you with the details, but a lot of the problem is that rule leaves it up to the prosecutor to identify the evidence as exculpatory or favorable to the defendant. And there's just an inherent conflict there. One of the courts in New York called it appointing the fox as the henhouse guard. Because the prosecutor believes that he or she can prove this person guilty beyond a reasonable doubt. They have no doubt he's guilty. And yet we're asking that person to identify what evidence can help the defendant to be able to understand the context of the defense position enough to recognize it as discoverable, and it's just too problematic to expect them to be able to perceive how it can help someone defend themselves who they believe is guilty.
Well, sometimes it's not just that the prosecutor may not be approaching it with a look that's straight down the middle. If the witness is Joe Smith, and the prosecutor has a statement from the witness that says defendant is guilty, the prosecutor may not know that Joe Smith and the defendant have been at odds and bitter enemies for years and years and years, and that Joe Smith lost his wife to the defendant or something like that. I mean, that's the sort of information that only the defense can understand and make use of. Or to take another example, photographic identifications are not admissible at trial. And so if a defendant is identified in a suggestive photographic array, the prosecutor doesn't turn it over because it's not admissible at trial. The defendant may not know that the later lineup identifications were tainted by the earlier suggestive identification. The prosecutor looks at the photos and thinks, ah, these look fine to me, but the defendant never learns about them.
Let me just jump in. If we open the prosecutor's files by repealing 240 and enacting 245, and just say if you have a police report, you give it to the defense, a lot of the problems the judge mentioned will just disappear because you're not asking the prosecutor to know the context of the defense case. If it's in a police report, let the defense lawyer use it and identify it and investigate it. And so that's one of the most important benefits of the changes that our task force has recommended.
Well, to reiterate, if it's up to the prosecutor to decide what evidence is admissible and would bolster a case, doesn't that create a conflict considering the pressure the prosecutors are under to get convictions?
Well, that's what the court called it, setting up the fox as the henhouse guard. In many situations it does. I mean, in some situations the prosecutors follow the rules nobly and properly, and if it's clearly exculpatory they give it over. But it's such a narrow rule that it doesn't address the main problems that we should rely on a discovery statute to address. We just can't.
Can we turn to Judge Dwyer? What about judges? We saw in the video that defense counsel turned to the judge for assistance. What can the judge do under 240, or what can't the judge do?
Well, there are a lot of things that the judges can do and a lot of things the judges can't do. If Article 240 specifies that witness reports or witness statements don't have to be turned over until trial is beginning, the judge doesn't have the authority to order the prosecutor to do any turnover of them until then.
And is that basically what we saw in the video where the defense counsel was asking the judge, well, let me see if the judge can intervene, and even despite the judge's efforts, the judge can't order that. Is that correct?
Sure. There are some things the judge can do if the judge has time. He's got time. You could ask the prosecutor to give you the witness statements and try to call through them and identify Brady material, that is, statements that are actually exculpatory that the prosecutor may not have seen. But boy, that's time consuming, and what are the odds that you're going to find that from grand jury testimony anyway? And there are other things you can do to put pressure on a litigant. You can offer the defendant a cheaper plea than the prosecutor wants, or all sorts of things to get things moving. But ultimately, if it's not in Article 240, the judge can't order it.
Mr. Schofield, what about prosecutors taking things into their own hands? I understand in Brooklyn the unofficial rule is that the prosecutors practice open file approach and share evidence, even though they are not required to do. Is that approach the best way to approach and address this situation?
Well, I'm the one who complimented the Brooklyn District Attorney by pointing out to you all that they voluntarily do this, but let's not get carried away. They do it in many cases, and the majority of cases, but there's a lot of very important, very serious cases where the Brooklyn District Attorney also plays hard and doesn't engage in this open practice. So if you're accused of a homicide, a sex crime, a rackets crime, and certain other categories, in Brooklyn they'll play as hard and as close to the vest as they do in Manhattan. So it's not perfect in Brooklyn. Is it the best approach to have prosecutors voluntarily do it? No. Because there shouldn't be different laws in each county of New York State. The New York State legislature should just say, this is fair, this is what Texas did, and we're going to do it here.
Going back to receiving evidence right before trial. So if you're given evidence at the start of trial, right before the trial starts, how do you test it? How can you investigate or look for witnesses to corroborate or rebut a statement if you only receive that evidence when the trial starts? And is this how it works in every case?
Well, certain categories of evidence the defense does get a little earlier, like scientific testing reports, because there you have to often consult an expert. So all the prosecutors give you that, maybe not as early as they should, but you do have that. So you do have an opportunity, by and large, to consult an expert, like a chemist or a blood expert or whatever the particular technical evidence is. You can do those sorts of investigations. Where we run into the biggest problems is you can't investigate witnesses if you don't know who those witnesses are or what they've told the police or what they've told the prosecutors. So how is the defense supposed to investigate a case when all you know about the case when your client is asking for the evidence is, I know what you've told me, the prosecutor won't tell me anything, so maybe they have a strong case, maybe they have a weak case, it's up to you. You can't do an investigation until you learn the witness statements, and sometimes that happens the night of trial.
I'm sorry, my understanding of the CPL 240 is that it requires those certain scientific reports to be turned over. So counsel's statement that most prosecutors give you that is really that the statute requires that to be turned over. And similarly, when prosecutors are not turning over information, I think the purpose of this discussion is that the statute doesn't allow it. So it's not that the prosecutors are, if they are not turning over evidence that is exculpatory, I agree with you that prosecutors are acting inappropriately. But by currently complying with the law as it exists in the state of New York, it is not that the prosecutors are withholding or choosing to turn over certain things, although they may choose to turn over more. But they're in compliance with the current statute, and I understand that it's the statute that there is an issue with, and not necessarily the performance of the prosecutors.
Well, what I said is that sometimes they don't turn it over as early as they should, and it delays the case a lot. But I also said the problem that defendants face is not with scientific testing reports. That's by and large okay in New York under the current statute. The problem is you don't have a right to police reports and witness statements, and that's got to change.
Sometimes
can we just ask one quick follow-up, Chuck? Sorry to interrupt. But in pointing that out from Jersey, as far as the difference between Jersey and New York, the Jersey statute does require that those pieces of evidence be turned over, whereas, like you said, New York doesn't require it, so it's not mandatory. It's not the prosecutors that are denying it.
Correct.
It's that they're not required to do so.
Correct.
And I think we saw some of that in the video as well. Chuck, go ahead. You think you had a question?
Yeah, I was just saying that, but you would think that it's a moral issue to turn over all evidence when someone is being charged with a crime, because it would just be much fairer. Isn't it the case that Mr. Schofield, isn't it the case that the DA has had the evidence for months and has been preparing their case since the defendant was arrested, and the defendant who has been sitting in jail for a long time doesn't get the same amount of time to prepare for their case, their innocence? Is that true?
Yeah, that's true. I mean, the prosecution has the police working for them. There's a great imbalance of resources. The police department has investigated the case. Sometimes they've investigated it as much as they want to before they then make an arrest. On the other hand, the defense, if evidence is turned over very late, has very limited time to investigate. Now, if we can make a showing that it's unfair and you have to let us investigate more, judges like Judge Dwyer will give us a little more time to do it. But there's an inherent imbalance with resources and time to investigate.
And that's unfair.
Yeah. Take, for example, a crime that happens in the defendant's favorite bar, and the bar has a video camera up, and the bar shows somebody committing a robbery. The defendant is saying it's not him. The defendant gets the video right before trial. He may recognize 20 people who were in the bar that night, and his investigators don't have time to go out and find and interrogate 20 people to see what they say about who committed the crime. And that may be an extreme example. I've never seen one quite like that. But it gives you an idea. There are just some things that you don't have time to investigate when you're picking a jury.
Mr. Schofield, what about plea bargaining? How does a person make a decision, or can they make the best decisions when they are basically in the dark? And I'm asking you, how do you counsel a client like that?
It's one of the very hardest things that defense lawyers do, because if you don't have information about the case, how can you give someone your informed opinion based on your years of experience, your anticipation of what the jury might do? All you can say is sometimes they have a strong case, sometimes they have a weak case. The one thing I can tell you is what the sentence range is, namely what sentence is the prosecutor offering you in a plea bargain if you accept guilt to a lesser charge or for a deal, and what are you risking if you go to trial and it turns out they have a strong case and you get convicted.
So, Mr.
The sentences can be, extremely long. You could say someone, they're offering you probation, the minimum, you could get 7 years after trial, you could get 15 years after trial, and that's a very coercive situation for someone who doesn't know the strength of the case against them. So like in the video, sometimes people do accept a plea.
And if I may, just to clarify for ourselves and for the audience, from what you're telling us and what the judge is telling us here in New York, it seems the issue is not actually the evidence itself but being provided, but when the evidence is provided and whether or not it's provided early enough to actually be able to do something with it. Is that right?
Yeah, I mean, the biggest problem is that witness statements are turned over on the day of trial as opposed to 15 days after the grand jury votes to indict you, which is a fair way to do it. And it would also improve the efficiency of the entire criminal justice system as well as the fairness of it.
And if the prosecutor turned over witness statements, written or recorded, what have you, early on, would the witness statements just in and of themselves be enough?
It would be a tremendous help, because then you'd be able to gauge the strength of the case, as a lawyer, gauge the strength of the case against the client, and as a client, know who's accusing you and what they're claiming, and be able to find evidence to support your innocence, or maybe the best thing to do is accept that plea offer.
This goes to the point raised by the Bergen County prosecutor, where she mentioned the possibility of witnesses not coming forward. What about if witnesses' information is given out? How do you deal with that and the possibility of witnesses' information being public or being offered to the defendant or feeling threatened?
There are a lot of ways to deal with it. For example, you could, and it's done a lot in Brooklyn, you could have information that only defense counsel is allowed to see. And you trust defense counsel not to send a hitman to interview the witness. You could have redactions in the witness statements so that the names are not there. You certainly don't always have to turn over addresses, though our report advocates that contact information, perhaps telephone numbers or email or whatever, be given out if addresses are not. And every case can be different. You'll have a general practice, but you'll have the judge able to make exceptions to the practice for cases where the DA can show a real need for it.
Can you tell us what CPL 245 is and what it's meant to do?
Well, CPL 245 is just the number that we came up with in our task force at the New York State Bar Association, because we drafted a model statute and a set of recommendations that we think would be a fair compromise, give the prosecutor ways to protect witnesses, but give the defendant opportunities to investigate and make informed decisions on pleas. So it's a whole new statute. It would replace 240, and we just decided to call it 245 because it was different.
And CPL 245 has at its centerpiece a protective order. Can you please explain that?
Well, that's kind of what the judge was describing a few moments ago. In any case where there is a danger to witnesses, and there are cases like that, none of us want to see witnesses harmed and intimidated. The judge would be able to, where appropriate, allow the prosecutor to withhold certain information or provide it only to the lawyer, not to share it with the client or with others who might be in a gang or a dangerous, pose dangers. It just gives the judge flexibility to ensure witness safety while maximizing the amount of information for the defense.
So basically the prosecution can at any time before handing over evidence move for a protective order?
Exactly. If the prosecutor has a concern, they approach the judge and the judge makes the final decision.
Is that automatically granted? Who decides if it's granted?
Well, it's up to the judge. It's not automatic. The judge can ask for more information, could interview a witness, could ask the defense lawyer without revealing the information, what do you think in general about this, why do you need it? The judge can solicit as much information as he or she needs and then make a ruling.
And what does a prosecutor have to show as far as why do they need it?
Well, the standard we recommend is just good cause.
Can you explain what that is?
In other words, any reason could justify it if the judge thinks it's legitimate and the dangers to a witness outweigh the need of the defendant for earlier disclosure. The judge can allow it to be turned over later, allow it to be withheld, allow it to be partially turned over, and good cause is meant to be very flexible. It's meant for judges to make and prosecutors and defense lawyers to make realistic judgments about safety of witnesses and the need for information.
And as a defendant or as a defense attorney or as the accused, are you aware that evidence hasn't been turned over theoretically under 245, the new law?
Well, our proposal is that the prosecutor would say, I'm withholding something. I can't tell you what it is, but I'm withholding something. And maybe the prosecutor would say what type of information. And then the defense lawyer could go to the judge and say, look, here are some factors that I want you to consider when making your ruling. This is what I would do with it. This is my counter proposal. It's a very flexible process.
But in that situation, at a minimum, the defense lawyer, according to you, is on notice.
Right. If there's some reason the defense lawyer has why there is no danger to the witness or a different approach could be taken, they can raise it with the judge.
So it sounds like the process is more open and it is automatic, but what about the timing?
Well, our task force is recommending that there be two stages of discovery. So like we talked about earlier, a felony case goes to a grand jury and gets indicted. How long passes between the arrest of the defendant and when you get the indictment depends on whether the defendant is in jail or not. Because if you're in jail, the rules are the prosecutor has to do that much faster. If you're out of jail, they have longer time. But after an indictment is voted in a felony case, our proposal is within 15 days, the prosecutor would turn over certain important information that the prosecutor has possession of in certain categories. And then the prosecutor would have a window of until 90 days after the indictment to gather from the police other information that it's just much harder for prosecutors to get. So if only the police officer has some handwritten notes or some vouchers or something that is harder to access, the prosecutor has longer. So in a nutshell, discovery is in two phases, and they're gauged to what is feasible for the prosecutor to accomplish.
And that's the general idea. It never works out that neatly in real life. There would, in the defense behalf, be a continuing rule that you've got to turn over exculpatory or Brady material as soon as possible after you receive it and identify it, without regard to the 15 days or the 90 days. In addition, there will always be cases where the prosecutor decides, when a new prosecutor is assigned to the case, to send the evidence to the lab for DNA testing. And the DNA test isn't done until a year and a half after the indictment. Obviously, that information is not going to be turned over 90 days after indictment. But that at least is a general framework that would get most of the discovery across.
You both recently sat on a task force commissioned by the New York State Bar Association. Can you tell our audience what the task force found in regards to New York's criminal discovery law?
Well, it pretty much found what we've just been saying all night. It found that New York is way behind other states in terms of disclosure. It found that there are many situations where that seems unfair and results in unfairness in cases. It recognizes that there are some cases where there shouldn't be turnover of witness names or whatever because of the dangers to witnesses. And it basically says, gee, let's bring New York into the 21st century.
Were the recommendations of the task force adopted?
By the State Bar House of Delegates, yes. It is now official State Bar policy.
And that was a unanimous vote, correct?
Yes, it was a unanimous vote.
Okay, so here's a simple question. Why hasn't it happened?
I think the second panel is where politics come up, isn't it?
The answer is politics. I think most people would say that the answer is that the New York State Senate has shot down or failed to pass proposals to remedy this unjust law for 30 or 40 years. And I would say it was a unanimous vote in our task force and in the New York State Bar Association House of Delegates. But prosecutors, most of the prosecutors, you know, you said to begin with, you invited all the New York State prosecutors, or many of them, to speak here tonight, and none of them showed up because they opposed this. And they've had influence over the years in the New York State Senate, and we're glad that there's a group like this that's going to start organizing to try to put pressure to change that.
Yeah.
Okay, we're going to turn it over to questions and answers in a moment. Just one last excerpt from the article that I'd like to share with the panelists and with the audience. This was a former judge who described New York's Criminal Procedure Law 240 as the worst in the country. And he gave a bit of a comparison to something that happened in a popular movie that many of you may be familiar with. My name happens to be Vincent Avagliano. I didn't look for this article. It found me, so don't accuse me of having handpicked this. But the account that he gives comes from a movie that you might be familiar with called My Cousin Vinny. And he recounts the fictional courtroom drama in which justice is served when the title character, an amateur lawyer played by Joe Pesci, saves two young men locked up in an Alabama jail for a murder they didn't commit. Vinny uncovers evidence showing that the only witness to the crime had trees blocking her view and was looking through a dirty window. He gets police records revealing that people matching the description of the perpetrators had been arrested in the neighboring county. Now the judge said, had the trial taken place in Albany rather than Alabama, Pesci's character wouldn't have had access to the information about the other arrests, the witnesses' names or statements, and maybe not even the name of the accuser. They were lucky to have been arrested in Alabama. The kids and my cousin Vinny would still be in jail in New York, he says. Any comments on that, or fans of the movie?
We will now invite some questions from the audience. Please go to the microphone to ask your questions.
All right, who wants to ask questions to the panel, the very informed panel? So in other words, if a person wanted to have fly out a police report, that it appears to me that even a FOIL request would be worthless. Is that true?
Well, while a case is pending, in other words, until there's a conviction or an acquittal or a trial, there's FOIL is the Freedom of Information law. There's an exception in that law that you can't get access to it for a pending case. So it would be worthless until it's too late, largely.
If I may, that's the same in New Jersey. Our FOIL law is called OPRA, which is the Open Public Records Act. And that would be for a request made by someone who's not a party to the case, trying to get police reports or other what's public information, and the same exception applies. So the documents that are subject to criminal investigations or that are documenting criminal investigations are not subject to public disclosure. But that's different than turning it over to the...
Okay, the next question is over here.
Good evening. My name is Sally West, and I've been formerly incarcerated and formerly accused and stuff like that. I came here in support of CPL 240. I just want to know what's the next actions that you guys are going to take it to the Senate, to legislators, in order to change. What's your next step?
That's the next portion of the panel. So if we could just take questions directed to the panel, please. These panelists that can speak to the CPL 240 law and not next steps.
Good evening. I also work for the Legal Aid Society, and I wanted to know, as far as individuals go, what can individual people do to help change this?
Again, that's the next portion of the panel, so we'll take that in just a moment.
Hello, my name is Jared. My question is related to something that was mentioned earlier, with you stating that prosecutors have the option but not the mandate to present this evidence to the defense. My question is, being that this is, one of the greatest cities in the world, supposedly, how can such a malfeasance continue and there not be stuff presented, things presented in the form of ethical conduct of the prosecution, knowing that there's evidence that could vindicate a client and they're deliberately withholding that evidence? How are the prosecutors still able to do that without their ethics being questioned?
Well, indeed, if the information is actually exculpatory information, the prosecutor can get in trouble under current rules for not turning it over. And we're seeing some police officers get in trouble these days, and we're seeing some prosecutors get in trouble too. It doesn't happen every day. It's a pretty rare thing for the system to turn like that. But it's now possible where Brady material is suppressed.
By trouble, what do you mean by trouble? What trouble do they get?
Well, you can get indicted, and you can get disbarred.
Okay, and if there's such an instance, would any criminal action taken against that be overturned against that defendant?
Yeah, that's what a lot of the wrongful convictions are that they're talking about in the press a lot. These are very often convictions where police officers in particular were found after the fact to have tidied up the evidence and so on. Those defendants do have post-conviction motions they can make, which can get them either a new trial or a dismissal. Of course, they may have been in jail for 15 years in the meantime, but at least once the information is exposed, they do have legal remedies.
As a former law enforcement officer who's seen the unfairness of this particular law, I'm going to direct my question to the prosecutor. And not looking at the extreme cases on the left or the right of this particular argument, but what would be the prosecutor's best argument? Because it seems like such an unfair law, and the repealing of the law seems like it's only fair what is the prosecutor's best argument, because I haven't heard one, to keep the old law? And I know it's unfair for you because you're in New Jersey, but as it reflects the prosecutors in New York, what is their best argument to keep the law as it is?
Well, you're right that it is unfair to me. I know, and I say that because I'm not here representing the district attorneys of the state of New York. But what I can say is this. I know that, as I believe it was the judge said earlier, there has not been a movement in other jurisdictions, for example, New Jersey, to repeal this law because of, to repeal our current discovery laws based upon witness intimidation and things like that. But I can also say that in fairness to the New York District Attorneys Association, there are no current studies or statistics that I'm aware of in jurisdictions where, like in New Jersey, where we've had an open discovery statute for so many years. There's no new information. No one's really taking a look at that. We've been living with it since, I think counsel said, since the late 70s. But there are concerns always about victim and witness intimidation. And I do not suggest that they necessarily outweigh fairness to defendants, but it's a part of the equation. And I think one of the fundamental, one of the things that we all get caught up in are these stories of wrongful conviction. And they're terrible stories, and it's abhorrent when law enforcement officers or prosecutors or anyone who's charged with this awesome responsibility doesn't play fair. But we're not talking about, the change to this statute is not going to change people who do wrong because they are wrongdoers. This requires prosecutors to turn information over earlier. But as I said earlier, it's one portion of the statute, of the whole entire statutory scheme. So there are other protections in place in the New York Code that don't exist in other places because it may balance out the discovery rule. I'm sure counsel would disagree with me. As I said, I don't speak for the New York District Attorneys Association, but the reality is there are other protections here that may not exist in other jurisdictions where there is early and open discovery because that's available to the defense. So there's a lot of other statutes, I think, that are implicated.
I'm sorry. Just as it relates to the victims, you know, out of the hundreds of arrests that I've made personally, and out of the thousands of arrests that I supervise, very small cases of victims being attacked by defendants. Very small cases. So if that's is that the strongest argument that the district attorney has?
Well, I don't argue for the district attorney,
No,
sir. Nor am I position here to be a proponent of the law. I leave that to the legislators. I'm just asking your opinion. I understand. I leave that to the legislators who are going to pass it or not. But I think it is. I think you're right. I think just like I believe that the number of law enforcement officers and prosecutors who purposefully withhold evidence is very, very small, I think, and I like to think, that the number of victims and witnesses who are actually physically assaulted or attacked is very small. However, the number of victims and witnesses who fear intimidation and who fear reprisal is very large. So when one is trying to win over the cooperation of victims and witnesses who have seen or been subject to horrific acts, there is great comfort to them to know that their names are going to be withheld, at least in the short term.
Okay, no, I'm just going to have to end it there because we have to move on to, well, Mr. Schultz, you have a counterpoint, and then we're going to have to move on to the next question.
The District Attorneys Association and all the local district attorneys didn't send anyone here to tell us what their reasons are.
Except we have a pretty good idea from our task force. We had 3 dissenters on our task force who were very smart and moral prosecutors. And in their dissent, the first 2 substantive subheads explaining their opposition were the proposed mechanisms to protect witnesses are inadequate, and the task force has given no consideration to the effect its proposals will have on witness cooperation or the impact the internet and social media have had on witness safety and privacy. I mean, that's the card they lead with.
And our task force rejected that argument as basically one that change can never happen. And even though it happens in the rest of the country and they have adequate mechanisms, for some reason these prosecutors are acting as if New York is exceptional and it can't, a safe system can't be enacted in New York, and we reject that position in the majority, and the State Bar Association unanimously voted to accept our proposal. So I don't think they have a leg to stand on, and eventually, hopefully, New York's statute will be repealed and will join the modern trend of the rest of the country and have open discovery.
Okay, thank you.
I understand I have the last question.
This is the last question, yes, Kenny, thank you.
So I just want, first I want to thank you for coming and enlightening us. Just for a lot of terms have been spoken about, but a lot of the prosecution in the Bronx and in Brooklyn always talk about Rosario, and you could just briefly explain that. And Brady, but we'll talk about that in the next panel. Thank you.
The term Rosario basically refers to written and recorded statements by the witnesses the prosecutor actually plans to call at trial. It's not a rule that they have to give you all witness statements or all police reports. They can pick and choose which witnesses they want to call and only give you those people's statements. And the big problem, which we've talked about all night, is they don't have to do it until you walk into the courtroom at trial. And then there's no chance to investigate those statements.
Okay, we'd like to thank our panel. If everyone can give them a round of applause. And now, after a brief break, we're going to be turning to our second group of panelists.
Okay, actually, before you even break, we just want to, again, thank the panelists, Ms. Coutinho, Judge Dwyer, Mr. Schofel, the moderators. And just so you know, we have been handing out the what we are calling the call to action cards, which we will explain later on. Also, this symposium is on live stream, which we will also give you the URL later on. And while we are going to continue our robust discussion on criminal discovery reform, we're going to do a changing of the guard, so to speak, so that we can begin panel 2. So while we are preparing for panel 2 and all of you are stretching and all of that, I want to just give a few acknowledgments. So if I mispronounced your last names, I'm sorry, I didn't mean to botch it up. And I will be we will be continuing to give more acknowledgments. First of all, Neva Schillingford King, Executive Vice President of 1199. She was instrumental in allowing Discovery for Justice to have this space here at the 33rd floor penthouse. We also have here in the audience former Assemblywoman Gloria Davis, 79th Assembly District in the Bronx. Thank you for waving. We also have here President Charles Jenkins, Coalition Black Trade Union and Transit Workers Union, Local 100 here. And Kenny Augusto, who's walking right now, but he's also waiting. He's representing State Senator Ruth Haskell Thompson, and he's also the elected state committeeman of the 78th Assembly District in the Bronx. Also, Council Member Andy King is here at the front. He will be the one to help continue the robust discussion on criminal discovery reform when we start panel 2 regarding the political landscape. And we also have Council Member Eugene Matthew here as an attendee, along with member of NYPD, 100 Blacks in Law Enforcement Who Care, No Leader. Thank you. We have Bill Bastard here. It can happen to you. Thank you, Bill. We also have Bronx Community Council for Unity, Faith, and Humanity, Sheikh Hakir Haq. They strongly support criminal discovery reform in New York State. All right, I think that's it for now. Oh, wait, we have more. Hold on.
We have Jerome Rice from the Co-op City, NAACP.
Thank you.
Now we got the session with what do we do with this information, okay?
All right, so panel 2 we have as panelists Council Member Andy King. We also have, in the stead of State Senator Ruth Haskell Thompson, Kenny Augusto. And the moderators are Miguel Santana and Julio Pabon. All right, let's start panel 2. Thank you. All right, so panel 2 we have as panelists Council Member Andy King. We also have in the stead of State Senator Ruth Hassel Thompson, Kenny Augusto. And the moderators are Miguel Santana and Julio Pabon. All right, let's start panel 2. Thank you.
Well, welcome again to round 2 of this criminal justice symposium that we're having this evening. Before I say anything else, I do have to give a shout out and thank you again to Neva Schillingford King, Executive Vice President of Not only is 1199 the largest healthcare union in the country, but I have to give him a special shout out because Neva's my wife. First lady. When I go home, I got to make sure I represent it well. So I just want to make sure I got that. Happy wife, happy life, I was taught. So, but the reality of what we're dealing with is, you know, what are the next steps? We heard the attorneys talk about the actual footage and the words that come with CPL 245. What I've done in the council is that after this conversation was brought to me, after meeting some young brothers that I knew growing up who spent time in Rikers because they didn't have early discovery, I myself then organized with Mr. Kenny Augusto along with the senator, made calls to Senator Perkins as well as Miguel Santana and Julia Pavone and Carmen, and thank you Mama Carmen, and Aisha Ahmed, who's from my chief of staff. And then I came up with a resolution that I presented to the city council calling for the end of CPL, repealing CPL 240 and instilling CPL 245. Currently, I have 17 members of the City Council who have signed on to this. We are going to, it's in committee right now. We will be having a conversation. I am also the co-chair of the Black, Latino, and Asian Caucus, and we're getting ready to take up the cause. That right there puts 25 additional members signing on to this cause because we represent communities who have been unfairly treated. You know, I listened to the conversation, and I think one of the problems that we do have is verbiage. And, you know, today in the council, we passed a law preventing discrimination based on your credit and how people are not allowed employment because of their credit history. Clearly knowing that it was a hit on communities of color who let's call it for what it is, who some of us tend to have some of the worst credit. And not just because it was our choice to have bad credit, but if you had a health incident that might have wiped you out financially, you know, you go into debt, and there's no reason why you should not be able to have a job because you might have a 550 credit score. That doesn't mean that you cannot be a good social worker. That doesn't mean you cannot be a good organizer. It does not mean that you can't be a good accountant. It's just that you ran into a situation. But discrimination is part of the American culture. I'm just going to say it for what it is. You know, this country is great as it is, and I love it, and I will do all I can to stand for it and help improve it. But I will say in time and time again to remind people it was built on a racial divide. We have the have-nots, we have the haves, we have the have-nots. We have the wealthy, we have the rich, we have the middle class, which is diminishing real fast, and then we have the poor. Now, how do we make sure that we keep, as we've talked about the pipeline prison, how do we keep it going strong? Well, you have to create scenarios that can consistently keep it happening. There was a point in our communities that we were fighting to get rid of drugs. And then when we've tried to get a handle on the drugs, then they said, how do we flip the educational system? Well, when they flipped the educational system on us, well, we started trying to get a handle on, well, let's take away their credit, just chat, you know, their credit. Well, if that's not working, well, let's see how we can hold them up in the jails as long as we can. Yeah. And I'd say, you know, one of the things that really could probably change all of this, if we just change the name, and it's out there, but we call it the criminal justice system. How about we call it the civilian justice system? Because if you treat people like civilians, the minute a prosecutor gets it, they're not looking at you as a criminal. I'm not trying to make a decision on you because I'm already looking at you as a criminal. Everybody can come to the game, talk about how do we get justice for our civilians. And that's what it is at the end of the day. You're still trying to get justice for the victim who might have been subjected to a crime perpetrated on them. So we got to figure out how do we have real language and how do we play the game fairly amongst each other. Prosecutors cannot, you know, we have a great prosecutor, the DA in the Bronx, you know, Robert Johnson stands, say, hey, we doing this. You know, the law says exculpatory, we have to give it up. You know, DA Johnson, listen, I don't want to give up that power, you know, because I'm doing the right thing. And I said to both of them, if we had 88 more of you around the state, we probably would be having these conversations. But we know that somewhere upstate, there isn't an attorney, a DA who's saying, I want to give up this power. Because it makes me almost judge and jury of how I move forth cases. But at the end of the day, who gets punished? We've heard testimonies from people from all walks of life, the color, but at the end of the day, we look at the statistics of the people who are actually being held up in Rikers Island. A lot of them are pretty dark-skinned people. So when we start talking about is it really fair, we have to still again talk about how do we uncover the discrimination, the prejudice, and the bigotry attitudes of America that lies into the fabric of our society. And this system is just part of it. And until we have the conversation to say that the system is discriminatory, we can do all that we can, jump up and down, stand in corners, but we got to get the people in the right positions that say we want to make the change. If we get the right people in those in the seats, we can make the change. We can make the change. So what does that mean? We talk about calling for action. If we know that we have elected officials in the Senate that's holding it up, it comes a point that we have to organize and create an environment and find the right candidate who's going to sit in the seat and say, I'm going to do what the people elected me to do. Not play games, not play politics. Because I find it appalling that the New York State Bar Association, that all these attorneys go to get their accreditation to make sure they can go out and preach law, and they give us to and say, this is what we must do, and we're still at this stage. Something is just wrong. So you have my commitment to continue the fight, to continue the work, to continue to stand on the street corner, continue to organize, continue to make more noise, talk to my colleagues, talk to the colleagues upstate, to make sure that we do the right thing by all our New Yorkers. We do the right thing in making sure that New York State, as much as we're supposed to be the progressive state, how progressive are we when Texas is leading us? Texas! Texas! You know, I went to school in Texas, and I'll never forget the day that I saw a sign saying KKK on the television. It blew my mind. I thought I was somewhere back in 40s, and this was just in the 80s. So I'm saying if a state like Texas can figure out how to be progressive enough to say we need to be fair about when it comes to treating our civilians that are in the justice system, then you know what, New York definitely wants to be at the head of the table. So you can count on Councilmember King to be an advocate. You can count on Councilman King to stand with you. You can count on Councilmember King to say whatever is necessary, because it's all about saving the lives of our brothers and sisters and not playing politics. Thank you.
Good evening. First and foremost, I want to thank Discovery for Justice for this beautiful panel, and of course, 1199 for being our host. On behalf of Senator Ruth Hassel Thompson, who's working every day, she's heartbroken she couldn't be here today, but she knows it was important that she be represented and that she is fighting a fight that's an uphill fight. Politics is who gets what. And if you're not at the table, you're on the menu. We saw in previous elections discussions. We have a district attorney association that is not interested in changing the dynamics of what happens. Now, this is very true that in our city, largest city in America, we do not have this law. We have 8 million people in this city, but this affects the 62 counties in the Bronx. I just show you a friend of ours, Bill Bastick. Not your typical New York from the Bronx, well-to-do, respectable pillar of society. This gentleman was accused of a crime. This gentleman was denied. So you could be white, you could be well-to-do, you could be a pillar of society, and you could still be at the wrong end of justice. We have to unite all 62 counties, from the richest county to the poorest county, and demand our governor, because we can make it as a program bill. Okay, we just saw an entire agenda upended by the necessities of a budget. Now, it's important to make that distinction that the budget is important also, but criminal reform is also important. And it's not something to say that we are demanding, we are asking what is basically the right to face your accuser. You have the right to face your accuser. You have a right to have your day in court. How can you have your day in court if your lawyer defending you has no right to vet the case, has no right to investigate what's going on, has no right to defend you? We have to change this law. Senator Ruth Hassel Thompson and Assembly Member Joseph Lenthal both agreed that we have to change this law. Now, the Assembly has no problem passing this. They have a clear majority in the Assembly. However, we have a very dubious distinction where we have a bare majority, but we have this independent Democratic coalition, and we also have the Republicans. And we're not asking that this be along party lines. We're asking that regardless of your party affiliation, your station in life, your education, that there's a fairness. Now, Mr. Bastick was able to exonerate himself, but it came at a very huge cost. Here in New York, on those barges, on Rikers Island, in the Tombs, we have many people who do not have the resources, don't own a home, doesn't have any way of getting an attorney or an investigator, more importantly, to find out the merits of their case. We have to find a law statutorily that it can do it. We have to impress upon the governor. We have to impress on our Republican friends on the other side of the aisle. We have to say, we have to work together. We need a majority. We need 34 votes, so we need 6 votes to make it, to make this statute a reality. We need the majority leader, and I don't know how to say this, but the leader of the Senate just was, it was reported that he himself is going in criminal investigation mode. There's a probe. So I don't know if that's, something, that we have to think about, hey, I'm in hot water. Maybe I had to think about making this happen. So we're looking at all these different things that when you're saying, you're innocent till you're proven guilty, that is the American way, but we have not had that justice. We're saying that it doesn't matter whether you grew up in the projects or in a trailer, in a mansion or in a hut. We are here to say that we have to unite this entire state and demand Albany responds to our grievances. We have to come and say the prosecution has to give more rights. If Brooklyn can do it, the Bronx can do it. Manhattan needs to do it. Queens needs to do it. We have to demand our prosecutors to do the right thing. Right now, just like Ms. Nazneen said when she was on the film, she says, I don't have any constraints to do it because the legislature hasn't passed the law. We have to pass this law. We have to do something. So what I'm asking you to do is, and I just wanted to give you the political landscape, because we've been meeting Discovery for Justice, and it can happen to you and wrongfully accused. I see Zulay over there. We have a lot of good groups together, and we need our unions and our veterans and our apple pie home owner and everyone to come out and say we need to do something. We have law enforcement that are saying it. We have prosecutors that are saying it. So we have to really mobilize to get those people on the other side, because the ones that are voting for it, the Democrats are voting for it. The Republicans are not. And we have to let them know that we're not shooting unguided missiles. We're saying, pan, pan, vino, vino, bread, bread, wine, wine. The time is now to open it. So we have to call upon the governor, because he's the one that has to sign it. And I'm a veteran of a couple of wars where we were able to persuade the governor to do something. So we had marriage equality. We had to pull 4 votes in the Republican side to make it happen. So this is not something undoable. Senator Ruth Astor Thompson, as the chairwoman of different committees, she was in the majority. When she was in the majority, they would have been able to put it up for a vote. We would have gotten into a huddle with the assembly. We would have gone to the governor and say, both houses want this, you got to do this. We got to remember, the governor was a prosecutor. He was the Attorney General of the United States. The Attorney General of the state of New York. So we have to impress upon everyone that just because you can get an easy win in court does not make it right. We are the voters. We are at the table. And if we don't eat, we're going to be eaten. Thank you very much.
Thank you. Thank you, Councilman King. What King has done is, by introducing it at the City Council, the objective is to stimulate public opinion. Because if we could get it past at the City Council level, it'll definitely resonate. Then we can start mobilizing folks to start going into Albany and actually lobbying all these particular state senators that are on the fence or are not voting, and so forth and so on. So it's a progressive stuff. We're looking at in a lot of different levels simultaneously. Folks that are working in Albany, folks that are working here downstate, like they say, working collectively, grassroots level, all different angles to get this message across. Whether it's now being streamed is, and I'm sure issues and their speakers are actually listening to this. The message resonates, but it has to start somewhere, and that's what we're doing right now.
And I want to, thank people like you, because, a lot of people who are here today, you took out the time to come here, and you probably didn't even think that all this information was going to be out here, right? But it is. And one of the things that we need to get it out there, you all have access to people, like I said earlier. Everybody that you know in your contacts, especially young people who love to be on your cell phones, Google this, Facebook this, Twitter this, put it out there, let everybody know. You have a number here. Everybody should be getting this card. Call that number, 518-474-8390. Tell Andrew Cuomo, tell your friends, can you just make one phone call? If you get all your friends, if everybody in this room gets 10 people, make a phone call to Andrew Cuomo's office with this number you got in your card. Take some of these cards home with you. Put them in the mailbox in your house. Be surprised how these little things work. We're going to continue to do this. We're going to continue to go, try to get on TV, try to get more on radio, try to get more stuff written on this. But one of the things we have to do is start talking their language. And their language is money. How much does it cost to go through a system where you might have an innocent person, bureaucracy of the court, eventually put them in jail and eventually get them out? We talked about the fact that if you incarcerate somebody illegally, they're going to come out. You know why I got involved in this even more? Because my son was a product of this. I have a son who graduated from this kid had never been to a demonstration, had never done anything wrong, to school for anything for him throughout his whole period. I was gifted with him. Not like my other 2 daughters who gave me hell. But through this kid, they're all cool. He was an angel. He was walking down 161st Street to go buy a sandwich. When he got to the Chase Manhattan Bank, he was walking. He's walking down with him. Let's go buy a sandwich together. Police came and they surrounded both of them because one of them was going, wait for me here, I'm going to go into the building. Went upstairs to pick something up. He came down. The police says, you went into a building that we've been watching. What's in your pocket? The kid, not knowing he's Dominican, he just been here. He opens up his pocket and he prints out a nickel bag. The police arrested my son. I go to the precinct, or was held on possession of narcotics and intent to sell. And I said, my son, impossible. But bottom line, and the judge, I wish I remember that judge, because I would like to give you that name, Tapia. That judge was kind of angry because he said, oh, just a desk and well, he's not going to get a desk appearance ticket. You know what the judge said to him? Well, he must, what are you trying to hide? That you don't want, you can't here? That's the attitude we have. So when those attitudes are there, we got to change those attitudes. The bottom line is, pled 2 years, they dropped the charges, but we did something else other people need to learn how to do. He sued the police department, and he case in business. So thank you, New York City. But those are the things that we have to teach our community, how much they would have saved if they wouldn't have to wait 2 years. How much money was spent for a case to be 2 years to go to trial? So we need to get those numbers. We need to get them there, go to school, Parsons schools or somewhere, and get people to break those numbers down, and let's show them how much money they would save if we were to have open discovery.
Thank you, Julio, for that. That was a good, great example. And we have another example here from Bill Pastic. He's going to give a quick comment.
Yeah, I just want to comment. First of all, I'm not going to go through my story because most of the folks with Discovery for Justice. But I want to reemphasize, first of all, what Councilman King said. Until you stretch the audience, okay, and get to white suburbia, okay, you're not going to tilt the pendulum for reform in Albany. It could happen to you. Has been somewhat successful in moving forward the establishment of a commission on prosecutorial conduct. But to get discovery reform, okay, I think you got to keep the argument very, very simple. Don't talk about discovery. Talk about exculpatory material. The average guy on the street doesn't understand that. What the average guy on the street does understand when you go and talk to them, because we go and talk to Rotary clubs and Kiwanis clubs, and white middle class thinks the system's working perfectly. They think everything's fine, and if they got charged with something, they pick up the phone, other family lawyer, they be in and out of the day. And when they learn that that's not going to happen, when they learn that it's going to cost them thousands of dollars to fight for evidence, because every time your personal attorney, I had an attorney, cost me $150,000 myself out of jail and a second mortgage, okay, and my wife's retired, okay, that's why I got. And once we begin to send that very simple message, let the average guy in the street know that he doesn't have that right. He's presumed guilty. He's not presumed innocent anymore. That's not the way the law works.
Maybe just to focus a little bit, concentrate on that, because we've seen that there are a lot of issues that this brings up. A lot of issues arise, and thank you, Bill, for pointing out your example. Many of us are familiar with it, but for those that aren't. That it frustrates, and there are a lot of issues that attribute to the problem that we have here. But to bring it back to...
Can I just add one thing?
We need a call to...
Okay.
Lose the people that
all right. But I just want to... The assistant DA from New Jersey, Rosewood Little hair I have left. Okay. She made the comment that we're making a big deal out of wrongful convictions. Okay, or at least implied that. All right. The fact that the other message we need to send is that when somebody is wrongfully, true perpetrator is up there committing another rape, committing another murder. That's right. And if you look at exoneree, whose conviction has been overturned, I can guarantee.
Thank you very much, people. We love you all. Please spread the word.
Gracias.
Excellent.